Southeast Radio's Business Matters with Karl Fitzpatrick.
Southeast Radio.
Good morning, I'm Karl Fitzpatrick and welcome to Business Matters. Coming up on this morning's show, the new employment legislation, which has been dubbed as the most significant change in Irish employment law for generations. We hear about the converted Odlum's grain store, which has rejuvenated St. Mullins, and why more businesses should be engaging in affiliate marketing. Well, next Monday, the Employment Miscellaneous Provisions Act comes into effect, and here to tell us more about what this will mean for both employers and employees is my first guest, Adrian Twomey from Jacob and Twomey Solicitors. Adrian, 6 months ago you joined me on Business Matters to discuss the Employment Miscellaneous Provisions Bill, which was making its way through the houses of the Oireachtas at that particular time. The bill has since been passed into legislation and comes into effect from next Monday. But perhaps you can remind us about the main provisions of this Act.
Well, Karl, there's a number of different headings addressed in this legislation, but the big headline grabber is that it's going to become a criminal offence with effect from Monday for an employer to fail to provide a written statement of key terms and conditions of employment to employees within 30 days of their commencing employment. You'll be in breach of the law if you fail to provide it within 5 days, but criminal offence after 30 days. So effectively the legislation, Karl, is going to criminalise employers who do not take reasonable care to try to ensure that contracts or equivalent written provisions are given to employees promptly upon their starting employment. And it's not just employers, it's also managers within those companies. So for the first time there's the prospect that HR managers or general managers, anyone who looks after employment issues, could end up being fined or imprisoned if people who are under their control don't get those contracts or statements of employment.
And why has the government taken such a draconian approach to employers in this respect?
Well, there's a range of employment legislation in place at the moment, Karl, and in one respect it's patrolled or policed by the Workplace Relations Commission. They've gone into a variety of different places of employment around the country and they've instituted prosecutions against employers for failing to comply with requirements in relation to wages, holidays, working hours, etc. But one gap in the legislation in terms of criminal offences has been in respect of the provision of written statements of employment or contracts to employees. And my understanding is the Workplace Relations Commission believes that that gap leaves them in difficulty in terms of enforcing a number of other statutory provisions. So they've put pressure on government to introduce this provision, and government has now responded.
So specifically with regard to terms of employment, what must an employer include in this written document?
The key provisions that must be given in writing to an employee within 5 days of their starting are the full names of the employer and the employee. That sounds obvious, but it's amazing how many employees are employed by companies they've never heard of. The second obligation is to clarify the address of the employer or the address of their registered office. Again, an employee may be mobile. They might actually not be aware as to where their employer is in business, where they can sue their employer if there's a problem. Thirdly, if the contract is temporary, you have to tell the employee how long it's going to last or the date on which it's going to expire. The fourth requirement is in relation to clarifying what they're actually going to be paid. And the fifth requirement is the number of hours they'll be required to work per day and per week.
0-hour contracts have been a contentious element of Irish employment law for many years now. So has this Act outlawed their existence?
Not completely, but it tightens the scope for the use of 0-hour contracts again. And I will say 0-hour contracts were in large part outlawed back in 97. So there's been some difficulty in using 0-hours contracts generally for a number of years, but now it's almost impossible. I think there's a little bit too much attention being paid to this particular issue in relation to the Act, Karl, because the Minister herself said, look, generally speaking, the Irish economy, we don't have huge numbers of people employed on 0-hour contracts anymore. It's possible to have one where, for example, there's an emergency situation and somebody needs to provide cover, but generally speaking, 0-hours contracts are a very dangerous type of contract for employers to use.
Why
when
so?
I mean a 0-hours contract, I suppose what I'm saying is a contract where the employee is required to be available for work but they're not guaranteed to get work. So the danger is you'll be sitting at home unable to do anything else, waiting for the call from your employer all week and never get an hour of work. Why is it dangerous? Well, I suppose the first thing is that under this Act, if you don't call people in for at least 25% of the hours for which they're to be available, then they can sue, and they will have an automatic entitlement to be paid in any event for 25% of their hours or 15 hours, whichever is less, but at 3 times the national minimum wage. So that could be a relatively lucrative way of spending your time at home. Second thing is you're going to be in breach of this legislation and you're at risk, again, of facing prosecution. And then there's a range of other claims that an employee can bring against an employer. They can say, look, this employer was using 0-hour contracts with me as a form of bullying, or it was causing me stress, which led to personal injury. A creative lawyer and an aggressive plaintiff can cause all sorts of trouble where 0-hours contracts are improperly used. So I'd steer away from them. There are other ways of addressing whatever flexibility you might require.
How does the Act govern businesses who hire variable hours employees?
With variable hours employees, the difficulty is that until now, certain employers, and I won't name any, but a lot of people will be able to think of one retailer in particular that attracted attention on this issue over the years. They'll issue a contract guaranteeing a very small number of hours to employees on a weekly basis, and then they'll call the employees in for far more hours than are specified in the contract. And the idea on the part of the employer is to get flexibility. Okay, so if I give a contract to an employee and say I'm going to give you 10 hours work a week, and the employee is then called in 30 hours a week every week, they're going to generally expect that they'll get 30 hours work. The flexibility that the employer assumes it has comes in when the need for a larger number of people on the shop floor decreases, perhaps because of a downturn in business, and they turn around and say, well, your contract only entitles you to 10 hours a week, Karl. We're cutting your hours from 30 a week to 10. We're still complying with your contract. There's nothing you can do about it. But your income has dropped through the floor. You're not able to pay your mortgage. You can't put food on the table for your kids. You've got a big problem. That problem is addressed under this legislation. So if over the period of a year, you're getting an average of, let's say, 30 hours a week, in our example we've just used, the legislation says you can go to your employer and say, I know my contract says 10 hours a week, but you've been giving me 30. That falls into a band under the new legislation. The band in that example is 26 to 31 hours a week. And within 4 weeks, the employer's compelled to effectively amend your contract and give you a minimum of 26 hours a week.
The draft bill contained a provision about independent contractors being mislabelled as employees. I know that you had raised concerns about this provision when you joined me on the show last year, but is this included in the Act?
No, it's gone, Karl, and fortunately it's gone. That particular provision was a real cause of concern for me when I last met with you to discuss the bill. It had been introduced into the bill as a result of an opposition amendment in the Dáil. I think it was sponsored by Willie O'D. It halted the progress of the bill through the Houses of the Oireachtas for a number of months, but that particular provision has now been removed from the legislation.
Many will say that this legislation is inequitable because it has the same standards for start-up businesses as it does for multinationals. Now, the start-ups and the SMEs would argue that they may not have the sufficient resources to comply with an act that's so onerous as this. So what simple steps can they take to ensure that they are not exposed to the possibility of criminal prosecution?
Well, with this particular act, again, the simple step you take is go and take appropriate advice from your solicitor, get them to draft you a contract, get a proper employee handbook, put them in place and review them every 2 years.
Some commentators are arguing that the Employment Miscellaneous Provisions Act 2018 places more obligations on employers in an already onerous legislative environment. So could this act actually and potentially have an adverse impact and effect on employment numbers here in Ireland?
I think it could be the straw that breaks the camel's back for some people, but I think if I was to say that this particular piece of legislation is going to have significant adverse impact, I would be exaggerating the situation. The Minister, interestingly, said that this was one of the most significant pieces of employment legislation in a generation. So maybe she thinks it's going to have a dramatic impact. I'm not quite so sure that it's as dramatic as she maintains. I'm not sure that this piece of legislation on its own is going to have a dramatic impact on employment numbers. It may reduce employment numbers very slightly because there will be fewer people out there employed nominally on 0-hour contracts, for example. No, I don't think this one is going to lead to longer dole queues.
Now, law is a very broad area and employment law is a very specialist area within that. As an employment law expert, are there any weaknesses with the legislation, or were there any specific areas where you would like to have seen addressed in this particular act?
Weaknesses in the legislation, I think, really an individual's view of the legislation will be coloured by whether they think it's right to criminalise employers in even more circumstances. I think the legislation does address one or two issues that needed to be tidied up. Most of those issues won't be of too much interest to your listenership, so I won't go into them in detail. There are issues out there that are just riddled with uncertainty. There are huge grey areas at the moment that still have to be addressed. So, for example, there's been some litigation over recent years in relation to the provision of reasonable accommodation to employees with disabilities. And nobody's quite sure at the moment how far an employer has to go in order to facilitate the employment of people with disabilities in certain circumstances. That needs to be clarified. The position in relation to interns and work placement students needs to be clarified. Why? Because the Workplace Relations Commission has recently announced that it regards it as being unlawful for an employer to take in a work placement student and not pay them.
Finally, the gig economy is expected to explode in the coming years, but could this present any difficulties from an employment law perspective?
I think it'll present massive difficulties because effectively people who are working in the gig economy are often independent contractors. They're self-employed and they're happy to be deemed to be self-employed when it comes to self-assessment for tax purposes, things like that. They feel they have greater freedom. But very often they become dependent on a particular company, a particular client, a particular employer for a large part of their income. And when that relationship goes sour, they suddenly wake up in the morning and find that they realise that all along they were actually employees. And they believe that they should be able to sue under the employment protection legislation. So there's a degree of uncertainty there. It's giving rise to claims. It's been giving rise to claims for as long as I've been in practice. But as the gig economy grows, the number of those claims is going to grow.
Well, if you've just tuned in, that was Adrian Twomey from Jacob and Twomey Solicitors, and I would like to thank Adrian for clarifying the particulars of this new employment legislation this morning. After the break, we'll be joined by Martin O'Brien from the Mulacon Cafe, who will be revealing why he selected the rural village of St Mullins for his business. So stay tuned for that.
Southeast Radio's Business Matters with Karl Fitzpatrick.